Kalorama, a recorded books/hybrid imprint, presents The Impeachment Power, the Law, Politics, and Purpose of an Extraordinary Constitutional Tool. By Keith E. Whittington. Read by Mike Lenz. Introduction. I first became interested in federal impeachments when I was working on my doctoral dissertation in the early 1990s. At the time, impeachments seemed like a particularly useful way to study how Congress exercised its constitutional responsibilities when it was working without a net. In an impeachment, the members of Congress have to take responsibility for their own actions, because the Supreme Court is not going to bail them out if they make constitutional mistakes. Impeachments can reveal something about how Congress thinks about the Constitution when left to its own devices. Moreover, high-profile impeachments shed particular light on how the American constitutional system has developed over time. They mark moments when Congress, and America broadly, has contemplated the foundational principles that ought to guide government officials as they work in the public trust. They are moments of constitutional restoration and sometimes of constitutional change. But no matter how interesting or illuminating such historical impeachments might be, they have been rare and seemed firmly anchored in the past. As with much scholarly work, my time spent studying impeachments seemed rewarding for its own sake, but arcane and distant from ordinary political life. Of course, it has turned out that impeachments, even presidential impeachments, are not simply a thing of the past. We have lived through more presidential impeachments than has any previous generation of Americans. We will probably live through some more. We live in an age in which every succeeding presidential administration has bred its own cottage industry of critics and opponents calling for impeachment. Before Donald Trump was sworn into office as president, books were being written calling for his impeachment. Before Joe Biden was sworn into office as Trump's successor, a newly elected member of the House of Representatives promised to introduce articles of impeachment against him. Such has been the way of our political life for more than 2 decades. My goal for this book is different. I come neither to bury Caesar nor to praise him. I do not mean to mount a prosecution of the current president and explain why he should be impeached and removed from office. Nor do I mean to mount a defense of a former president and explain why his impeachment was unjust. Such works have their place, and there are examples of them aplenty. This is not one of those books. Instead, I hope to illuminate the constitutional nature, purpose, and history of the federal impeachment power, not from the perspective of how it might help or hurt a particular government official, but from the perspective of how we have thought and should think about it over the long run. It can be a useful exercise when thinking about constitutional powers to consider how we should understand that power, not only when it is being used by our friends, but also when it is in the hands of our opponents. My views on the impeachment power were shaped from the study of our history, before impeachment politics entered contemporary American life. They have been deepened and informed by the events and controversies of the past quarter century, as I have sought to apply those early lessons to emerging problems. But my view of the impeachment power was not developed in the heated partisan environment of a particular impeachment. I have been both critical of and sympathetic to aspects of every impeachment that has been pursued over the course of my adult life. I have tried, during those controversies, to share the lessons of my studies of the Constitution and the impeachment power to improve the public understanding of the process and the political use of this important constitutional tool. I hope the reflections in this book can be helpful in thinking about the controversies yet to come, and that it can help shed light on the impeachment power without turning up the heat. The conventional form of referring to the Senate when it tries an impeachment case is as the High Court of Impeachment. This style is borrowed from the British practice, where the House of Lords sat as the High Court in impeachments there. But the British Parliament was a high court in a broader sense as well, since it traditionally exercised some judicial powers that were somewhat comparable to the role that the Supreme Court plays in the American system. Parliament was, quite simply, the highest court in the land. The U.S. Senate is not a high court in that sense. It only plays the role of a court in a single, special circumstance, when members of the House of Representatives come to the Senate chamber to impeach a federal officer. The Senate has more rarely been referred to as the constitutional court of impeachment, but that appellation has special significance. In the American context, the Senate sits as the constitutionally specified court of impeachment. When the Senate is gavelled to order as a court of impeachment, it does so under constitutional directive, in accordance with constitutional forms, and for designated constitutional purposes. It is a court specially constituted by the Constitution. Thus, advocates have sometimes referred to the constitutional court of impeachment in order to emphasize the constitutional form, and, on occasion, to question whether the Senate is living up to it in practice. The friends of President Andrew Johnson questioned whether it was even possible for the Senate in 1868 to form a constitutional court of impeachment for its trial, because almost one-third of its members was excluded by the refusal of the Republicans to seat senators from the states of the former Confederacy that were still under Reconstruction. His sympathizers wondered whether the Reconstruction Republicans appreciated that it was not the Senate as a political body that should have been trying the case. Only a properly formed constitutional court of impeachment was authorized to play that role. President Johnson's Attorney General had earlier tried to emphasize to the justices of the Supreme Court that a sitting president cannot be made subject to the jurisdiction of any court while in office, except only the Senate of the United States, as the constitutional court of impeachment. When the Senate sits as the constitutional court of impeachment, it does so as the highest and final court under the Constitution, and thereby exercises an especially solemn constitutional responsibility. The Constitutional Court of Impeachment is empowered to resolve the gravest of constitutional questions and to hold accountable the highest governmental officers in the land. When the senators assume that mantle, only the people themselves stand above them. Not long after the drafting of the U.S. Constitution, a member of the British House of Commons rose from his seat to defend, for nearly the last time, the existence of that great constitutional instrument of public safety, the impeachment power. That instrument might not always be used wisely or well, but it should call legislators to recognize and assume their most solemn place in the constitutional order. In the following chapters, I develop an explanation of the scope and purpose of the impeachment provisions of the U.S. Constitution. We have to understand the nature of the impeachment power in order to answer pressing questions about how it should be used and what we can reasonably hope to accomplish by its use. Answering such questions might not have been considered pressing during the long periods in American history when federal impeachments were rare, but calls for the use of the impeachment power are no longer rare and no longer confined to the political fringes. The argument presented here draws on many sources. The constitutional text is an essential starting point, but the text by itself leaves us with many interpretive puzzles. The purpose and history behind that text is clarifying, as are our established practices in making use of the impeachment power. The impeachment power is an important piece in the intricate structure and design of the Constitution, and it reflects not only the worries that the founding generation had when imagining how Republican politics might work in a new nation, but also our persistent fears about how government power can be abused and how those abuses might be remedied. The impeachment power sits at the intersection of our dual commitments to democratic self-government and constitutional restraints on political power. Making sense of that power and how it should be responsibly used requires thinking through both our democratic and our constitutional commitments and how they operate in our modern political world. My perspective throughout is one informed by history and politics. The impeachment power is not just a legal instrument, it is also a political tool. There is a meaningful law of the impeachment power rooted in our text and tradition that bounds its use. Within those bounds, however, political judgment is required to know whether and when and how it should be used. The impeachment power is designed to remedy a distinctly political problem of the misconduct of an officeholder. It is exercised by political officials who must not only make contextualized assessments of whether another political official has engaged in grievous misconduct, but also consider the range of options that might be available to address that misconduct. When legislators reach for the impeachment power, they should know what they hope to accomplish and have some idea of how the impeachment power might be used to reach that goal. Exercising the impeachment power involves choices about how politics is to be conducted, how misbehavior is best remedied, and how we can best secure our highest constitutional ideals. Choosing well depends on the wisdom and experience of the elected members of the legislature who serve in the Constitutional Court of Impeachment. Those choices can be informed by lawyers, scholars, and experts, but they cannot be dodged. Ultimately, legislators are held to account for how they make those choices by their constituents, and they alone bear the burden of persuading their colleagues as to what actions are needed and of justifying to the voters what has been done. Legislators need to understand for themselves and be able to explain to others the reasons for their choices. Why did they act or fail to act? Why did they pursue action in this way? What other options were available to them, and how did they assess the risks and rewards of the path that they chose? Were they satisfied with how events played out? Did the proper people learn the proper lessons, or were mistakes made along the way? Voters should demand answers to such questions, and members of the legislature should be confident in their ability to provide an adequate response. In the following chapters, I both clarify the law of federal impeachments and illuminate the choices that political officials must make when contemplating whether to use the impeachment power. For the general listener, there are points explained here that are widely accepted by scholars on these topics. But there are many claims developed here that remain points of contention. If this book can help enlighten and inform our scholarly and political debates about how the impeachment power should be used, then it will have done its job. 1. What is the impeachment process? More than a century before the American Revolution, the impeachment power enjoyed its heyday in the House of Commons of the British Parliament. The memory of those days was fading, but not yet forgotten, when Americans were drafting their state and federal constitutions after shaking loose from the British Empire. The Americans remained impressed with the parliamentary battles with the British monarch in the 17th century, and they were happy to borrow the weapons that Parliament had used in those battles in order to help defend their own republican aspirations. In 1624, King James I gave a prophetic warning to a favorite courtier, George Villiers, the Duke of Buckingham, and to the prince, the future King Charles I. Both had encouraged the impeachment by the British Parliament of a rival at court, Lionel Cranfield, the Lord Treasurer. James was not pleased. Using his pet name for the Duke, James declared, "By God, Stenny, you are a fool, and will shortly repent this folly, and will find that in this fit of popularity you are making a rod with which you will be scourged yourself." The prince was 8 years the Duke's junior, but old enough to anticipate wearing the crown himself. James had words for him as well, that he would live to have his belly full of Parliament impeachments, and when I shall be dead, you will have too much cause to remember how much you had contributed to the weakening of the crown by the two precedents he was now so fond of. Within just a few years, James would be dead, and the freshly coronated King Charles I would have to dissolve Parliament in order to head off the impeachment of the Duke of Buckingham. 2 decades before issuing that warning to his son, James had unified the kingdoms of Scotland and England under his own rule. His reign saw the flowering of English literature and the arts, from the writing of the plays of William Shakespeare to the translation of the Bible into English. But not everything was running smoothly in England at the beginning of the 17th century. The Catholic terrorist, Guy Fawkes, had tried to blow up Parliament just after James had assumed the English crown. While still ruling over Scotland alone, James had published a controversial tract laying out his theory of the divine right of kings and his expansive views of monarchical power. He had advised his eldest son, Henry, who was felled by typhoid fever as a young man, hold no parliaments, but for necessities of new laws, which would be but seldom. For few laws, and well put in execution, are best in a well-ruled commonweal. King James had never been a fan of quarrelsome legislatures. James had offered that written advice when Prince Henry was still a small child, and when James ruled only over Scotland. When Queen Elizabeth died in 1603, James united the two kingdoms under his own rule. It did not take long for the English Parliament to give James new reasons to wish them out of session. The first Parliament to meet under King James I wound up petitioning the king for permission to arrest and sue some of his minor functionaries, who the House of Commons thought were abusing their offices. James informed Parliament that only the king had the authority to punish his servants, and would do so as he saw fit. Not long after, James dissolved the Parliament. When his other schemes to pay off the royal debt failed, James was obliged to call Parliament back into session, but quickly dissolved it again when he thought he had found an alternative source of funds. Some members of Parliament were left to wonder whether they would ever be called into session again, or whether this was the end, not only of this, but of all parliaments. But eventually the king wanted money to raise an army, so he once again summoned Parliament to assemble. Rather than simply raising taxes and going home, that Parliament too began investigating abuses by friends of the king, and questioning the king's foreign intrigues, including the negotiations with Spain's King Philip III for a marriage between his daughter and Prince Charles. Such an impertinence led James to issue a proclamation explaining to his Parliament that while he was an indulgent king who would allow of convenient freedom of speech, his patience had limits, and the parliamentarians should henceforth avoid an excess of lavish speech, and stop talking of matters above their reach or calling. Sir Edward Coke, a famed jurist, and now a member of Parliament, took the lead in developing a response, and eventually the House of Commons put before the king a bold assertion of a liberty to speak freely as in their judgments shall seem fittest. The king allowed the members to return home for Christmas, but when the festivities were over, he had the elderly Coke sent to the Tower of London, where he was held for 9 months, and ordered the Journal of the House of Commons brought to him, so that he could personally rip out the page recording the protestation. He then promptly dissolved the Parliament. In addition to adopting its protestation in defense of a freedom of speech in Parliament, the House of Commons made another bold move in 1621. It revived the impeachment power. Parliament had not impeached anyone since the reign of King Henry VI, more than a century and a half earlier, and the possibility of such a power was barely remembered. The notorious outrages of Sir Giles Mompesson spurred Parliament to search its dusty records for a power to act. Mompesson had proved entrepreneurial in securing monopolies from the king that allowed him to harass and extort businessmen and enrich himself and members of the king's inner circle. Sir Edward Coke reported to the House of Commons that the searchers have discharged their duties, and discovered that according to former precedents, the House should address ourselves to the Lords, and so it was agreed to go to the Lords and that the committee examine all his offenses. The king chose not to waste political capital trying to protect Montpesson, and the disgraced knight fled to France before the House of Lords could pass sentence on him. Having rediscovered this medieval power, the Commons became enthusiastic about its use. It is not clear that Coke or anyone else in 1621 had settled on a name for this practice of the Commons, acquainting the Lords that we had fallen upon some grievances, that the two chambers together might all join in the punishing, but at some point it began to be referred to as impeachment. John Pym, another leader in the House of Commons, boasted that the High Court of Parliament is the great eye of the kingdom to find out offences and punish them. He was zealous in ferreting out those offences, but his targets were rarely close to the king. Indeed, the king held the trump cards in the game of impeachment, and Parliament's enthusiasm for it proved to be short-lived. In one of his last addresses to members of Parliament, King James I warned that they were treading on thin ice in impeaching the Lord of Middlesex. Parliament should remember that they should make the punishment no greater than his crime. Ultimately, the king would have the last word. And now, how far I find they have proceeded according to my rules, so far I will punish. How far I find they have exceeded, I will add mercy. As for bribes, if he have taken any to the detriment of the party, I will punish it. The king cautioned the Commons as follows: But as it is lawful for grieved men to complain, so I would not have an inquisition of Spain raised in England, that men should seek to inquire after faults. But if complaints come to you, judge of them accordingly, but search not for them. But I must warn you for the time to come of one thing. Men shall not give information against my officers without my leave. If there be cause, let them first complain to me, for I will not have any of my servants and officers, from the greatest lords to the meanest scullion, complained on by any without my leave first asked, but I will make them smart sorer that complain than he is complained of. Neither will I have any man to presume to go to complain as if there were no king in Parliament. I will not suffer it. Even Pym recognized that Parliament might be able to declare, through the impeachment power, that a punishment should take place, but for execution left to the king wholly, who hath the sword. It was left to the king to strip an officer convicted in the court of impeachment of his titles and offices, imprison or exile him, or worse, and the king might instead choose not to follow up on Parliament's judgment at all. The king might pardon an individual who fell under the great eye of the kingdom. The king might even suspend or dissolve the Parliament and put an end to its investigations. When Parliament turned its sights on the Duke of Buckingham, the intimate friend of the king, in 1625, King Charles I played his card, informing Parliament that the king, perceiving the Commons resolved to reflect upon some great persons near himself, this Parliament was declared to be dissolved. When Charles called the Parliament back the next year, he gave them a stern reminder of where they sat in the British constitutional order as he understood it. Parliaments are altogether in my power for the calling, sitting, and dissolution. Therefore, as I find the fruits of them to be good or evil, they are to continue or not to be. The conflict at the beginning of his reign between King Charles I and the Parliament did not bring an end to the British practice of impeachments, but its limitations were already visible. In the 1640s, the Commons attempted to take on great persons near the king, and the results were not encouraging. What the Parliament really wanted and needed was an instrument for taking control of the government, and the impeachment power was too crude a tool to serve that purpose. As the Commons pleaded with the king in the Great Remonstrance of 1641, it hoped that he would employ such counselors, ambassadors, and other ministers in managing his business at home and abroad, as the Parliament have cause to confide in, even if we may be unwilling to proceed against them in any legal way of charges or impeachment. That conflict between king and Parliament degenerated into civil war, and Charles lost his head in 1649. In the century and a half before American independence, impeachments were part of the process by which Parliament tried to gain control over how public policy was formulated and administered. To realize in practice what one pamphleteer in the early 18th century said was a noble maxim of our Constitution, which expressly makes the ministers accountable for all transactions contrary to the interest and honor of their nation, by punishing those who have so many times brought us to the brink of ruin. Convincing the king to adopt the practice of dismissing ministers who had lost the confidence of the Parliament realized that goal more effectively than did impeachment. The impeachment power was just a way station on the road to votes of no confidence. When the first edition of what would become a classic treatise on the law and practices of Parliament appeared in 1844, its author could safely treat impeachments as a thing of the past. The power of parliamentary impeachment was, to be sure, a safeguard to public liberty well worthy of a free country, and of so noble an institution as a free parliament, but happily, in modern times, this extraordinary judicator is rarely called into activity. The British constitutional system had discovered better tools than impeachment for remedying most political ills. Perhaps if the U.S. Constitution had been written a few decades later, the American founders would have emulated the system of ministerial accountability that eventually developed in England. In the mid-19th century, the third Earl Grey would say the ministers of government exercised the powers belonging to the Crown, but were considered entitled to hold their offices only while they possessed the confidence of Parliament, and more especially of the House of Commons. No impeachment power was necessary if executive officers were understood to serve at the pleasure of the legislative majority. But that was not the system that the American founders imagined or designed. Executive officers in the American system were to be independent agents of the people and were not mere instruments of the legislature. The founders imagined that the executive branch and the legislative branch of the American Republic could clash, as they had in 17th century England, though hopefully without the necessity of the chief executive losing his head. The executive would not be subordinate to the legislature, but rather the executive and legislature would be yoked together in a system of checks and balances. The impeachment power was part of that system, helping to keep the executive under control. Few principles were so central to the founding era thinking about constitutional design as that power ought to be made to check power. The records of the Philadelphia Convention, where the delegates met in the summer of 1787 to haggle over a new set of constitutional rules, are replete with discussions of how adequate checks on power were to be established. Although only 34 years of age, Edmund Randolph was one of the elder statesmen of the convention. He had served for a decade as the first Attorney General of the state of Virginia, and he was taking a break from his duties as governor when he traveled north to lead his state's constitutional delegation. Once the delegates had assembled in Independence Hall, Randolph was chosen to launch the substantive business of the convention by introducing the Virginia Plan, the first outline for a new federal constitution. As the debate got underway, Randolph urged the convention to accept the proposal for a bicameral national legislature. The evils that plagued the United States since the end of the American Revolution could be attributed to the turbulence and follies of democracy. Some check, therefore, was to be sought for against this tendency of our governments, and he hoped the Senate would do the trick. North Carolina's Hugh Williamson similarly hoped that a legislature divided into two chambers could serve as a mutual check, while James Madison hoped to provide Congress with a check against the mischiefs of the states. The delegates would accept only a watered-down version of that particular check. When the convention began to consider Virginia's proposal for a council of revision that could veto bills from the legislature, Elbridge Gerry of Massachusetts thought that judges should be left off any such council, since they would already have a sufficient check against legislative encroachments on their own department. The judges, Gerry thought, would hold a power of deciding on the constitutionality of legislation, and would therefore be able to set aside laws as being against the Constitution. Gerry thought there should be a check on both the constitutionality and the wisdom of legislative proposals, but that judges should concern themselves only with the former. Benjamin Franklin dissented from the council idea, at least, which he thought was a mischievous sort of check that would encourage corrupt bargains between the legislature and the executive. His fellow Pennsylvanian, the future Supreme Court Justice James Wilson, worried instead that if the legislature could override a presidential veto too easily, the executive check might prove inadequate in tempestuous moments to the task of allowing the executive to defend itself against an overweening legislature. Checks had to be put in place everywhere, the Federalists believed, so that no actor or interest could become too powerful or abusive. The ultimate and most powerful of these checks, the impeachment power, was entrusted to the Congress. With this power, the legislative branch alone was vested with the authority to remove, when necessary, members of the other branches of the federal government. Members of the legislature could themselves be removed by the chamber as a whole, through expulsion, or
Sample complete. Ready to continue?